Ram Ram ji, welcome to Legal Lens. In this video, we will discuss a landmark judgment wherein we will first talk about facts of a case, issue involved in the case, arguments from both the sides, and lastly, decision with reason. This video will be useful for the students preparing for judiciary as well as CLAT, and also for advocates preparing for AOR examination. So please do like, share, and subscribe my channel.
मद्रास बार एसोसिएशन वर्सेस यूनियन ऑफ इंडिया। आप साइटेशन देख सकते हैं, बेंच का नाम देख सकते हैं, डेट ऑफ जजमेंट देख सकते हैं। ब्रीफली मैं बताता हूँ कि इन दिस जजमेंट द सुप्रीम कोर्ट एड्रेसेस द इंडिपेंडेंस एंड एफिशिएंट फंक्शनिंग ऑफ ट्राइब्यूनल्स इन इंडिया। द कोर्ट वाज टू डिसाइड द कॉन्स्टिट्यूशनलिटी of provisions concerning the selection, appointment, tenure, and condition of service of this tribunal. So now we will decide the facts of the case. So in this case, there is an association named as MBA challenging the constitutionality of the various provisions of Tribunal Reforms Act 2021 relating to the structure, appointment process, service, condition, and tenure of the member. Earlier, the tenure was 4 years, but later by this act, it was earlier the tenure was 5 years. By this act, the tenure was decreased to 4 years, and after this act, the minimum age limit was 50 years for appointment as a member of the tribunal. There was also appointment of the member was through search cum selection committee, which was dominated by executive, because more members in such committee was from executive side. By this act, the legislature has reintroduced the provisions which were earlier struck down by the Honorable Supreme Court in various judgments, such as MBA Madras Bar Association was a Union of India 2010, Roger Matthew was a South Indian Bank 2019, MBA was a Union of India 2020. So these particular judgments struck down some provision, but the legislature, in order to show its supremacy, in 2021 they introduced an act called Tribunal Reforms Act 2021. So this is the facts wherein the Tribunal Reforms Ordinance 2021, which later became the Tribunal Reforms Act 2021, was challenged. So these were the contested provisions which were challenged in this act. So now we'll see the issues. What were the issues in this case? The issues were whether the provisions of the Tribunal Reforms Act 2021, especially regarding tenure, age limit, appointment, violates the principle of judicial independence and separation of powers. Secondly, whether Parliament can enact law that override or ignore binding precedents of the Supreme Court under Article 141. Third issue is whether the structure of tribunal appointment as laid down by the 2021 Act is constitutionally valid. Now, if we want to understand what is tribunal in few sentences, see, tribunal is a quasi-judicial body. It acts as a court, and the purpose of creating tribunal in India was to decrease the number of cases which were pending in the high courts and supreme courts. So, and also the district courts also, because there are many tribunals which are receiving cases at lower level also. So the aim was to create a body which acts as a quasi-judicial body. We cannot say the judicial body, because in that the judges, one is judicial member and the other is expert member also. So that acts as a quasi, and in further appeal against that order, you can go to High Court and Supreme Court, and also according to the Act which provides that power, within that Act also it is written how to move, how to appeal, or where you can file revision, appeal, and everything. So accordingly we move in this particular Act. So now what is the arguments? So from the petitioner side, that is Madras Bar Association, so their arguments were based on violation. First argument was that this particular act violates the judicial independence. Now when we see what is judicial independence, it is the basic structure of the constitution, and we follow separation of power, not in strict sense like USA, but we do follow it. And here they said that this particular act violates the judicial independence, because if you appoint someone for a shorter tenure of 4 years, this will lead to discourage among the judicial member, because we see that, like, if the case is pending for 4 years, it takes around like during admission stage also it takes around 3-4 months during admission stage also. And in the tribunal or any court also you see that you get a date of 3-4 months. So if any judge will be sitting for member is sitting for 4 years, so in 5, 6, 8 dates the matter will not be there. The other judge, other member will come again, he will listen. So the case, the main purpose of creating tribunal will all be abolished, so it will not be met. So that is why they say that it violates the judicial independence. And secondly, they also said that frequent reappointment will create dependency on executive, and that also if the executive will appoint anybody, so in order to favor the person who has appointed him, this will somewhere it will influence the decision also of the courts, tribunals. Secondly, the submission from the petitioner was that is it is contrary to article 50. Now what article 50 says? Article 50 says that there should be separation between judiciary and executive. Now where the executive will control appointment and service condition, so the main purpose of article 50, that separation of judiciary and executive, will be violated. Therefore their submission was that it is contrary to article 50. Now third is disregard of judicial precedent. Now when we see article 141, so it says that any judgment of the Supreme Court is binding on all the courts, and it is in the form of law. So where in this what the legislature has done, that earlier judgment was there which was it was overruled, and a new act was reintroduced, creating all the acts which all the provisions which were struck down by the honorable courts, and the same provisions were included in the new act, and it was giving a new phase of Judicial Tribunal Reforms Act 2021. So it was contended that that it disregarded the judicial precedent, which is law according to article 141. And fourth submission was unreasonable age restriction. Now what is saying, what the submission was, that if you are citing and if you are giving an age, minimum age of 50 years, so this will restrict the qualified candidates, and especially the candidates who are advocates at bar and who are practicing in bar. And if you limit the age, so at the age of 50, if you are saying that if anybody who is eligible and who can be a good who is a qualified candidate, but if you are fixing a 50 years of age maximum minimum limit, so it will disqualify that qualified candidate also. So somewhere and therefore they are saying that this is an unreasonable age restriction. The loss of tribunal efficiency, obviously if your tenure will be shorter tenure, and there will be unclear reappointment process, and mostly if the appointment and reappointment process will be based on pleasure of the executive, so I think that this particular tribunal system is ineffective, and it is fragile, and it is totally dependent on executive. So these were the submission from the petitioner side, that is Madras Bar Association. Now what the respondent is saying, that is Union of India by Attorney General, what he is saying. So he says that Parliament's legislative supremacy. He says that that we follow the separation of power. Now when we say about separation of power, then he says that Parliament has power to enact law, and Parliament has a supreme authority to enact law, and provided that he addresses the defects pointed out by the court. And secondly, he is saying that this particular act, that is Tribunal Reforms Act 2021, is not a replication, rather a fresh justification and policy reasoning is provided in this act. This was said by the respondent, that is Union of India. Now the second is saying that that is policy domain of the executive. Now he is saying that executive has power, is a power to make policy and take decision regarding policy with respect to matters of tenure, age and qualification of the members in tribunal, and it is the wisdom of the legislature and executive to do. And they also said, there was a submission that the court should not legislate from the bench. And basically they are saying that this is our role, this is our because we follow separation of power and legislature has power to enact a law. So they are saying that we have wisdom, and we have full power to create policies and make decision with respect to tenure, age, qualification of the members. Now thirdly, he is saying respondent is saying that reforms necessary for efficiency. Now he is saying that reform is necessary for uniformity, transparency and faster recruitment. Now and secondly, he is saying that shorter tenure of 4 years makes member more accountable and performance driven, what they are saying. But I think instead of making performance driven, this is what I am saying, uh, it will create more it will create more pendency of cases, because it will not be decided in 4 years. Now the fourth submission is no violation of judicial independence. What they're saying, that such cum selection committee includes judicial member, and therefore it says that it is not a violation of judicial independence. And what they're saying, that there is adequate balance and check. But the member of executives, like if you are including two judicial member and if you are including four or three executive member, so how it will be balanced? It will not be balanced, because executive will always support executive only, because they are one who is appointed by the executive only. So that is not this is not a reasonable argument. But the respected attorney general has said that we are respecting it. Now, lastly, the judgment of honorable court. The Supreme Court partially allowed the petition of and struck down the several provisions of Tribunal Reforms Act 2021 for being unconstitutional. Now, what were the key holdings? That for tenure struck down. Now, the court reiterated that the member must be there for at least 5 years. And the court said that the 4 years tenure discourages meritorious candidate. Now, secondly, with respect to minimum age limit of 50 years, it was struck down, and the court said that it is arbitrary and restrictive for advocate who wish to join earlier. And the court also said that there is no reasonable, it is not supported, this minimum age of 50 years is not supported by reasonable classification. Thirdly, the court said that executive overreach in appointment is condemned. So what the court is saying, that the such selection committee which you are creating must be majorly composed of judiciary, and the executive member will not have casting vote, they will not have right to vote. So now the according to the judgment, the such selection committee composed of Chief Justice of India and his nominee, who should be a retired judge of Supreme Court or the Chief Justice of retired Chief Justice of High Courts. And secondly, there will be two secretaries from the executive side, from the executive side. So there will be, so this there will be equal balance, like two from this side, two from judicial side, two from executive side. Reaffirmation of binding nature of precedent. The court says that Article 141, that any law, any parliament cannot enact law that disregard or nullify a Supreme Court's judgment without curing the legal effects, on the ground that it violates the basic structure. Lastly, direction to follow earlier judgments. The court said that all the laws which were made, which were struck down in the previous judgments of the Honorable Supreme Court, should be kept in the mind. And the court said that strictly follow the Madras Bar Association 2020 judgments. Now, what are the reasoning of the court? Judicial independence is a part of basic structure of first reason. Second is check and balance must be preserved. बहुत easy है, बहुत check and balance होना चाहिए, ठीक है. Because see, if Parliament has power to enact law, legislature has power to enact law, so the judiciary has also power to while applying judicial mind, has to see that any provisions, any act should not violate the articles of the Constitution. So the judiciary has its own power. Now, if any law which is enacting, which the legislature passes it, and if it violates the articles of the Constitution, provisions of the Constitution, so it is the job of the judiciary, it is the job of the court to struck down that particular provision. So judiciary is also acting in its own power, and legislature is also acting in its own power, because the judiciary is given as a guardian of the, is acting as a guardian of the Constitution. He has its own power. So say there is nothing like a judiciary is intervening in legislative power or legislature power. And most important thing, that all the three are acting together. There is a you can say there is a check and balance between all three. We are not following separation of power in a strict sense like USA. Thirdly, the reason is short tenure will lead to executive control. Fourthly, is power of judicial review cannot be neutralized. Now, fifth, the reason is need for independent and efficient tribunals. As said, the goal of tribunal reform should be strengthen judicial functioning and not to weaken it by bureaucratization. So concludes the conclusion is that the case of Madras Bar Association versus Union of India is a crucial affirmation of judicial independence and constitutional supremacy. अब ये देख लीजिएगा. The Supreme Court legislature cannot override judicial pronouncement without removing the defects. Tribunal must function independently, free from executive interference, and secure tenure and merit-based selection. So this is the last. This is the conclusion part. You should read. एंड बेसिकली यही था कि इंडिपेंडेंस ऑफ जुडिशियल सिस्टम जो ट्रिब्यूनल का इन द केस ऑफ ट्रिब्यूनल उसको कोर्ट ने बहुत अच्छे से डिसाइड किया है. और कोर्ट ने इसमें जैसे इसमें नेशनल ट्रिब्यूनल कमीशन को भी एक कोर्ट ने बोला था कि ऐसा एक बॉडी होना चाहिए नेशनल ट्रिब्यूनल कमीशन जो कि दैट विल डिसाइड और विल लुक विथ रिस्पेक्ट टू द अपॉइंटमेंट एज सर्विस एंड कंडीशन ऑफ द मेंबर. तो इन दिस केस ऑल्सो तो बेसिकली इंडिपेंडेंस ऑफ जुडिशरी को प्रिजर्व करने के लिए ये पर्टिकुलर जजमेंट आया था. सो लास्टली आई वुड रिक्वेस्ट यू टू प्लीज़ डू लाइक माई चैनल, सब्सक्राइब माई चैनल. आई ब्रिंग मोर एंड मोर जजमेंट्स इन वेरी ब्रीफ वे. लास्टली मैं ये भी सजेस्ट करूँगा कि प्लीज़ रीड द फुल जजमेंट इफ़ यू वांट टू. बट बेसिकली जो इंपॉर्टेंट है मैंने समझा दिया है एंड दिस इज़ वेरी सफिशिएंट फॉर एनी जुडिशियल सर्विस एग्ज़ाम और CLAT exams. For AOR exam also it is sufficient, but I'd request you to, if you want to read the full judgment, it will help you. तो आप वहाँ भी देख सकते हैं. So thank you. Please do like and subscribe my channel. Thank you. जय हिंद, जय भारत.